Weekly list item number 20. My please, Your Lordship. My Lord, Your Lordship, last occasion raised four questions. That one is that,
Be little louder.
my Lord, one that the conduct of the witness, that is the PW4, that he is the only sole witness, basing upon relied upon which the entire conviction. Second, that the extrajudicial confession before a person who is not so close to the appellant.
Hmm.
And my lord, the third one is that the delay in receipt of the affair and the part of the abscond. And my lord, in that light, in the conduct of the witness, the light, I am going through a very recent judgment of Honorable Apex Court in my lord, Pradeep versus State of Haryana. In that, there is a murder of the mother and the minor child of 10 years with only with the mother, and he stated that extrajudicial confession made before one milkman in the morning. That death occurred in the night, and the extrajudicial confession made in the morning. That is,
Extrajudicial confession.
uh,
Who has committed? Who had
I
committed?
beg pardon. I beg pardon. He make the that our mother is no more before
He disclosed before the
my
milkman to have seen the occurrence.
my
About seeing the occurrence, that disclosure was made in the morning hours.
in the morning hour.
In the night, the occurrence took place.
In the
Okay.
my and he that milkman is not examined.
Yes, huh?
That milkman is not examined by the prosecution.
Yes.
And it is stated that there is a quarrel between the father of the minor child and the accused persons,
Hmm.
and the father also not examined. So my lord, I am pressing that judgment when there is crucial witnesses are left out,
Hmm.
like in this case the informant and her wife,
Hmm.
and only case is only based upon the minor child who is the only eyewitness. That in that case, what is the aspect of Honorable Apex Court?
Hmm. Close it up. No, before going to
My,
place that,
my,
just understand it about the factual scenario it's here. Because the ratio of a particular case would be applicable in the other case if the facts are similar. If there is a little variance, then that may not be applicable. It is not a straitjacket formula that wherever delayed disclosure is made, the witness is to be discarded. His evidence is not to be accepted, right?
right.
So, if he offers an explanation as to why he immediately did not disclose before anyone, including police, and if the court finds that that explanation to be satisfactory, right,
Mm.
then the court can accept his evidence. Here, this witness, if you find the age is 10 years,
Right.
he was perhaps called to go for hunting.
But
So, according to him, the deceased was moving ahead, and just to the back of the deceased, the appellant was there, and this witness, PW4, the child witness, was moving back to the appellant. And he has seen that how twice the appellant dealt blow with a stone to the head of the um, deceased. And if you come to the postmortem report,
Right.
the doctor, it is PW3, and the doctor has stated that he noticed fracture of occipital bone, and the injury is antemortem in nature. And he also found that the corresponding injury to the fracture of the occipital bone was the laceration of brain. And he also opined the cause of death was due to hypovolemic shock due to intracranial bleeding and cerebral anoxia due to profuse bleeding. So, no, head injury is responsible for the death, and this child witness has stated that twice with a piece of stone the blow was given. Apart from other things, how he just tied the stone around his waist and then threw it inside that nala. All these things he has stated. The most important thing is that when the occurrence took place, this child witness was trying to run away, go away from that place, but the appellant threatened him not to go, otherwise he would face dire consequence. So the child stayed there, saw the rest part of the occurrence. That means he tied by where that stone was tied, and then it was thrown. And again, that child witness says that I was threatened by the appellant not to disclose. So it is possible on the part of a child who is aged about 10 years and who has seen a ghastly murder being committed in his front. Okay. And the dead body was thrown, and when he was threatened by the appellant, he might be apprehending that if I disclose before other persons, I might be also killed, and the appellant may assault me also. So that may be the reason for which he remained silent, right? But when the police came to know, because in the first information report it is mentioned that they had gone for bird hunting. So obviously the police came to know that there might be some kind of clue with this boy. So when the police came, examined this boy, the boy might have got confidence that that fear psychosis which was there because of that threat given by the appellant might have gone away, and that was the reason why he disclosed about the occurrence on 12th. So merely because he from 10th to 12th he did not disclose before anyone, including of course police, his family members, including the informant, let us say informant. So question that in this situation, particularly the age of the and the threat given, whether his evidence is to be disbelieved only on this ground, because you are not pointing out any ground except that he made a delayed disclosure, because whatever he has stated, the oral evidence is getting corroboration from the medical evidence, right?
Right.
So in this peculiar scenario, whether is a child who is aged about 10 years seen a ghastly crime being committed in his plot, threatened by the appellant not to disclose, kept mum for 2 days. And when the police came to him, yes, you could have advanced that point. Suppose in the first information report, there would have not have been anything that this boy had done with the appellant and the deceased. Then the question comes for consideration, if this boy has never disclosed before anyone to have seen the occurrence, how the police came to know that he had gone there, he has seen the occurrence, anything like that. But the fact that the informant had seen three persons, going to for the bird hunting. One is the appellant, second is the deceased, third is this eyewitness, the child witness. So that is how it is mentioned in the FIR. So police got the clue and came to this boy, examine him. So in such a scenario, why you say that merely because for 2 days, let us say, he did not disclose before anyone, including police and including the informant, let us say, whether his evidence is to be discarded.
My lord, the boy have the opportunity when they are coming back.
Hmm?
When they are coming back, they meet with the informant. When the informant asks Pradhan Bodra that where is my nephew? At that time,
No, informant has that is a informant has not stated, or there is no because informant was not examined.
my
Informant has not stated in the FIR that he came to ascertain the whereabouts from this boy. Has he stated in the FIR?
no, my lord, but the boy
Right?
was there.
Yeah.
But the boy was there.
No. Stated after fishing, the appellant, his wife, and that boy,
Mine.
they were returning at page 15. At page 15, fifth line from the top.
शाम को जब मैं
From the top.
I made it.
मैं ड्यूटी चला गया, शाम को जब मैं लौटा तो देखा प्रधान, उनके बीवी रानी और मैं जब ड्यूटी चला गया। अच्छा
ज-
नहीं नहीं, वो दोनों के साथ, अच्छा शाम को नहीं शाम को जब मैं लौटा द पूर्व लाइन था, वो दोनों के साथ हमारा पड़ा का एक 10 साल का बच्चा भी था, राइट? हाँ, जिसका नाम गार्जी सामया, दिस इज PW4,
Right.
राइट?
Right.
हाँ, देन शाम को जो मैं लौटा तो देखा प्रधान, उनके बीवी रानी, पूर्ति और वो छोटा बच्चा नाला में मछली मार के पड़ा वापस आ रहे थे। मेरा भांजा ना घर में था ना इनके साथ था। इसलिए मैं प्रधान को मेरा भांजा का बारे में पूछा तो वो बोलने लगा कि मोटा को वो ओड़पड़ा में छोड़ दिया, पर मेरा भांजा रात को घर नहीं लौटा, इसीलिए इधर उधर ढूंढ रहे थे। आज सुबह तक कोई खबर नहीं था। आज करीब 10:30 बजे खबर मिलने के एक अनजान आदमी का लाश से डूबे का कॉलोनी का पास इल्लारी नाला में पड़ा हुआ है। वहां जाके देखा तो कुछ पुलिस वाले ने उस लाश को पानी से उठा के जांच कर रहे थे। मैं लाश के पास जाके अच्छे तरह से पहचाना, वही लाश मेरा भांजा मोटा पुटी का है बोल के पुलिस को बताया। पुलिस अपना कार्रवाई करने का कर रहे थे। घटना बारे में मैं पूछा तो मैं शुरू से जो हुआ था, लास्ट जो हुआ था बारे में कुछ whitener बारी it has been inserted later on. Seems to be. कहने के बाद मुझे पुलिस ने पहचान Here also he has stated he saw उसके बाहर के निकला हुआ था, कमरे का घुटन श्वांसु जो बंधा हुआ था, सिर का श्वांसु, गला में श्वांसु, ये सब कुछ देखने के बाद मुझे पूरी तरह से महसूस हुआ कि राहा ने मेरा भांजा को मार दिया है। हत्यारी मेरे भांजा को मर्डर करके उनका कमर और घुटना में पत्थर बांध के लाश को छुपाने के लिए नाला का पानी में डाल दिया है। मैं इस हत्याकांड में प्रधान बोंद्रा को पूरा शक करता हूँ। This that means this query which was made from the appellant, that was in presence of his wife uh, appellant's wife, Bibi Rani Purti, or this PW4. Hmm. So he was the IT of the occurrence, and he was threatened by him not to disclose the same before any authority Chile. Again, going with them for fishing. Some seems to be answering story. कहाँ कहाँ से मैं किसी यही मैंने संग गए क्या संभाले मार्च मारी की सी शाम को जब मैं लौटा तो देखा प्रधान उसका बीवी सुहांशु स्वाम तो छोटा छोटा बच्चा नाला में मछली मार के बड़ा वापस आ रहे तो लोग जौन को मारी देवे बीता सही छुआटा को नहीं फिर माछ मारे हुए तुमसे भी unbelievable. Se puso un volado de cura que le estaba por analizar otra que le analizar right and the fact still cut up the correct. The contradiction here stated पेज 15 प्रधान का बाएं हाथ में लाल रंग का इलेक्ट्रिक तार था तो देखिए कि ये जान करोगे तो the entire story has been read subsequently. What this decision says, please which paragraph you want to place? Come to paragraph number 8.
Right.
The decision which you cited, yes.
Right. It is well settled principle that corroboration of testimony of a child witness is not a rule but a measure causation and prudence. A child witness of tender age is easily susceptible to tutoring. However, that by itself is no ground to reject the evidence of a child witness. The court must take careful scrutiny of the evidence of a child witness. The court must apply its mind to the question whether there is a possibility of the child witness being tutored. Therefore, scrutiny of the evidence of a child witness is required to be made by the court with care and
Caution.
Before recording evidence of a minor, it is duty of a judicial officer to ask preliminary questions to him with a view to ascertain whether the minor can understand the questions put to him and is in a position to give rational answers. The judge must be satisfied that the minor is able to understand the questions and respond to them and understand the importance of speaking the truth. Therefore, the role of the judge who records the evidence is very crucial. He has to make a proper preliminary examination of the minor by putting appropriate questions to ascertain whether the minor is capable of
whether the minor is capable of understanding the questions. Yes.
Put to him and is able to give rational answer. It is advisable to record the preliminary questions and answers so that the appellate court can go into the correctness of the opinion of the trial court. In the facts of the case, the preliminary examination of the minor is very sketchy. Only 3 questions were put to the minor, on the basis of which the Lawrence Session judge came to conclusion that the witness was capable of giving answers to each and every questions. Therefore, the oath was administered to him. Following are questions put to him. Question number 1: in which school you are studying? The answer: I am studying in government primary school, Barswavan, Barwasni. Question number 2: what is occupation of your father? My father is a pujari in mandir named Hanuman at Gohanba. So, should one speak truth or false? Answer: truth. We are of the view that the Lawrence Session judge has not done his duty. Nevertheless, we have carefully scrutinized the evidence of the minor witness Ajay in the examination chief. He stated that on the night 30th December 2002, the accused entered his house by breaking a window. While the appellant held his mother by his hands, accused number 1 assaulted her with a knife. When he tried to rescue his mother, accused number 1 gave a blow on his back by knife. He stated that he was hiding in house after accused fled, and he disclosed the incident to milkman Surender, who came to the house at 5 a.m. In the examination in chief, he deposed about the incident of cutting of crops on their family land by accused number 1 and 2, which had taken place 6 to 7 months prior to the date of offense. He stated that though the accused indulged in the said act, no action was taken as the appellant's father apologized. In the cross examination, when the witness was confronted with his statement recorded by the police, he admitted that this incident was not recorded therein. In the cross examination, the witness volunteered that the accused present in the court had murdered his mother and they were drunk. However, he accepted that the allegation that the accused were drunk was not recorded in his statement recorded by police. The incident had taken place after midnight. In the cross examination, the witness stated that the accused, before coming to his house, has disconnected the electric supply. He denied the correctness of suggestion that due to darkness, he did not recognize the assailant who assaulted his mother. He came out with improved version in the cross examination that accused number 1 had a little matchstick and in light matchstick he recognized the assailant. It is very difficult to accept the accused number 1 who gave 6 to 7 blows by knife on the person of the deceased would light a matchstick while assaulting the deceased. At this stage, we may make a reference to the evidence of PW6 Rajinder Singh, uncle of Ajay. He claims that on 31st December 2002, when he had gone to the cattle shed at about 5 am, he heard from milkman Golu that Satpal's wife had been done to death. He claims that he rushed to the house of the deceased. As PW1 did not open the door, he jumped over the wall, entered the house. PW1 stated that PW6 did not enter by jumping over the wall. As he opened the door to facilitate the entry of PW6. However, PW6 claimed that the intimation was given to police only after his brother Satpal arrived. PW6 is not an eyewitness. According to the prosecution case, till 5 am, PW1 was hiding in his house, and only when the milkman Golu Surender came at 5 am, he disclosed the incident to the said milkman. In fact, even PW6 stated that he became aware of the incident from the said milkman. The prosecution has not explained why the milkman was not examined as a witness, though he was available. He was a very important witness who gave the first person to whom PW1 Ajay disclosed what he had allegedly seen. Till the milkman came, there was no one who had tutored Ajay. Therefore, what the witness conveyed to the milkman would have been crucial in the context of the allegation of tutoring. He was a very important witness available whose examination could have ruled out the possibility of the witness being tutored, as he was the first person to meet the minor witness after the accident. Afterwards, the minor was in the company of his uncle and his father, and according to the prosecution case, there was some dispute between the family of Ajay and his father. PW6 in cross examination stated that the milkman was present outside in the court when his evidence was recorded. His evidence was recorded on 22nd December 2003. On the same day, the Lorraine trial judge recorded statement of public prosecutor that he was not examining Satpal as being unnecessary and he was dropping Golu as he was won over. Even the appellant's father was a crucial witness. This is a case where an adverse inference will have to be drawn against the prosecution for non-examination of the milkman and the appellant's father. There is another circumstance.
That is if that is not relevant. That is footmarks.
Hmm.
But what has happened in this case
Hmm.
that this PW1, who is the eyewitness, saw the occurrence in the midnight, and he disclosed about the occurrence early morning. That is at about 5 o'clock when the milkman arrived, and he disclosed. So they said that since he was the very first person before whom the disclosure was made, and thereafter there was chance of tutoring that witness, that milkman should have been examined. What was the first version of that PW1 before the milkman? That would have been a vital factor.
Hmm.
So, and the prosecution has withheld that vital witness. So, though the other witnesses have been examined, from whom uh, to whom this milkman has narrated the occurrence, but they say that milkman whether has stated this or that is the statement of those persons who alleged to have heard from that milkman, they might be adding something. So that is why the court said that the importance of uh, here, as we find from the FIR, that in that very evening, the appellant, his wife, and this boy,
Right.
this PW4, they were found returning after catching fish, right?
Right.
And this informant met them. And at that point of time, he asked, of course, PW4 that where is my nephew? No, not PW4. Sorry, to the appellant, where is my nephew or the deceased? He said that he had gone to another place, which is named as Goudapada. So at that point of time, maybe that the child was in with the appellant, and the appellant has given threatening to him not to disclose. That might be the reason that why at that point of time PW4 did not disclose before uh, the informant. Otherwise, he might have known the occurrence. So had it been alone, uh, so that may be the one. Yes. Yes, something number of judgments. That is there. In spite of that, they have not disbelieved uh, the child's witness only on the ground that the questions answers are not recorded. They said that this should have been done, and but no, again they but again they assess the evidence to the appellate court to assess. Right, that is yes. But again, we are also of the same view in the previous. That is the other thing. But again, they have stated that there are some decisions that we say that if really, right, because the manner in which he is answering to the public prosecutor, the manner in which he is facing the cross examination, those are also to be taken into account. While disclosing this fact for the first time today, I did not disclose to anyone as the accused had threatened us. I was examined by police. A police this was police examined him after recovering the dead body, right? And an FIR was ତାପରେ ସେ ତାମାନେ ସେ କହୁଛି ପୁଲିସ ଛଡା ଆଉ ସେ କାହାକୁ କହିନି ଆଜି ଆସି ପ୍ରଥମ ଥର ପାଇଁ କହୁଛି. That does not exclude police. He said that I was examined by ଆମେ ତିନିଟା ଏକାଠି ପଢିବାକୁ ପଡିବ. Meaning ହଉଛି police କୁ କହିଥିଲି ତାପରେ ମୁଁ ଆଉ କୋଉଠି କହିନଥିଲି. It was stated so in the prosecution, not in the examination. No, no, no. That is, they have extracted it from the witness. So this particular line, which is there in the FIR,
Right.
at that point of time, there was also the reason why the child did not volunteer to disclose that he had seen the occurrence, that the appellant committed the murder, because the appellant himself was present there. Appellant had given the threatening. Appellant had committed murder according to him, given threatening, and when the informant met appellant and his wife was very much present in the company of that child. So that was the reason maybe that he could not have got the courage uh, to disclose that no, he had not gone to Goudopada as reported by this appellant, but this appellant has committed murder. You see, just see the plight of the child.
And from the FIR, from the version of PW4, it is stated that in the FIR it is वो दोनों उनका दोस्त प्रधान बोल रहा तो they are there is a cordial relationship. There is a cordial relationship between the deceased and the appellant. The PW4 also stated that we are going in a row. So what is the reason that he suddenly
That you see,
that
you cannot read the mind of a person.
my
Maybe that something has happened. Who knows? And unless this type of relationship is created, he might not accompany. So that may be the ground why some kind of cordial behavior is shown. But he might be searching for that opportunity when to get and finish him.
right.
So he got the opportunity and killed him.
The 161 that is not with me when Lordship removed, that is written that after that we took bath.
Hmm.
The minor and the appellant. That after this occurrence we took bath. Then the evening incident that we are fishing. There is the wife of the appellant number one. There is the wife of the appellant also there. Because there is
No, at that point of time, wife was not there.
in the evening.
PW4 has not stated why. They returned back.
Minor.
Subsequently, it shows that they might have gone again for fishing.
It is the FIR story.
It is the FIR story. FIR, the informant has not. It's not that perhaps you are telling that the informant, the appellant's wife was present at the scene of occurrence when the assault took place. Nobody has stated so. That was, they were returning after catching fish in the evening hours, not. So this occurrence took place around 12 noon to 2 o'clock. Okay. That was over. They returned back. Might have thereafter might have gone for fishing again.
Madam, I am saying that there is a opportunity. Every opportunity is there to say his family members or so many. He after if he is returning back to the assailant, one of the accused murderer, that is
You see,
seems like doubt.
somebody might be when somebody is given threat, particularly age, he might be trying to keep himself safe in a position till he gets that confidence. He might not be disclosing. So when that is why in number of cases also where antisocials commit the crime, most of the witnesses they even though they give their statements before police, okay, 161 are there, but when they come to the court, they don't support the prosecution case. It's not that somebody has threatened them or there was direct threatening to them, but they just disown the statement on the ground that something might happen to us, something might happen to our family because they are hardened criminal, and who can give security to us, to my family. Police is all right, police is now with me, but tomorrow I have to attend my works, my family members, my child would go to attend the college. So that is the main criminal jurisprudence, that is the main factor for which so there is a that there should be witness protection. It's not that only that is to be provided till the trial is over, but it should continue thereafter, right? Otherwise, nobody would come forward and speak what they have seen actually, particularly when the other side is a hardened criminal, number of criminal antecedents are there. So that is every chance that, and that is exactly happening. One is, you are right that one is they are either by, they are threatened thereafter. Suppose the appellant, the accused is released on bail. There may be either he directly or through other means might be putting pressure, might be giving money also, uh, or doing something so that to gain over the witness. That is one aspect. But in this particular case, the child is just aged about 10 years. He accompanied, according to him, and saw the occurrence, threatened, and when an informant met him, the appellant was in his company. and he disclosed it for the first time when the police uh, came to know that this man had, uh, because the other man was absconding. Appellant was not there. So the only source they could know, police ଦି ଜଣକୁ ପଚାରିଥାନ୍ତା ନା, ଯୋଉ ଦି ଜଣ ଯାଇଥିଲେ ଗୋଟେ ଫେରାର ହେଇଯାଇଛି, ଇଜ ଦି ଆପେଲାଣ୍ଟ, ଦି ଅଦର ମ୍ୟାନ ଇଜ ଦ୍ୟାଟ ବୟ। ପୁଅ ପିଲାଟା ପାଖକୁ ଯେତେବେଳେ ଆସିଲେ, ପିଲାଟା ଘଟଣା କହିଛି, ରେକର୍ଡିଂ କରିଛନ୍ତି ତାର ଷ୍ଟେଟମେଣ୍ଟ। ତ ଏଇ ସର୍କମଷ୍ଟାନ୍ସ ରେ ବିଲେଟେଡ ଡିସକ୍ଲୋଜର 2 days ପାଇଁ ୱିଟନେସ୍ ଟାକୁ ଡିସବିଲିଭ କରାଯିବ କି ନାହିଁ, ଏଇଟା ହଉଛି crux of the matter, particularly when his evidence is getting corroboration from the medical evidence. Motive, another thing, motive also assumes no importance when there is direct evidence in this case. Hala? Karano, motive is there, always there in mind. It is very difficult for the prosecution in every case to say that this may be the particular reason for the. It is very difficult to unearth that is in the mind why a person is doing a thing. It's not always possible to. So, but merely because the prosecution doesn't come forward that this is the particular motive, that cannot be a ground to disbelieve that eyewitness account of the prosecution case. If the direct evidence or the eyewitness account is believable, trustworthy, so merely because motive is not forthcoming, that cannot be a ground. There are several pronouncements in that respect.
Another aspect is there kind of the last scene. The last scene is only described by the informant. There is father, mother of the minor child.
You are right to the extent that the informant was a very vital witness in the sense that informant had seen that last scene aspect he would have told. Number two, this disclosure which was made by the appellant, that he could have also told. Number three, he would have been the witness to the inquest also because he was present and signed the inquest report. And thereafter, he would have been the best person to say as to why in the inquest report he did not create any doubt against the appellant. But immediately after few minutes, କାରଣ ଏଇଟା ଗୋଟେରୁ ଗୋଟେ 40 ଭିତରେ ହେଇଛି, ଆଉ ଏ ଏଫଆଇଆର ଲଜ୍ ହେଇଛି 2:15ରେ। ତେଣୁ 1:40ରୁ 2:15 ଭିତରେ ସେ କେମିତି ତାର ମାଇଣ୍ଡ କୁ ଚେଞ୍ଜ କଲା, ଯେତେବେଳେ ଇନକ୍ୱେଷ୍ଟ ହଉଛି ଆପେଲାଣ୍ଟ ଏଗେନଷ୍ଟ କିଛି ଡାଉଟ ନାହିଁ, ସେଥିପାଇଁ ଇନକ୍ୱେଷ୍ଟ ରିପୋର୍ଟରେ ଆପେଲାଣ୍ଟ କୁ ସନ୍ଦେହ କରାଯାଉଛି ବୋଲି ମଧ୍ୟ କିଛି ନାହିଁ, ପ୍ଲେନ୍ ଆଣ୍ଡ ସିମ୍ପଲ, ଇଜ ଏ ସିଗ୍ନେଟୋରୀ। ବଟ୍ ୱିଦିନ୍ 40 half an hour, let us say, he is changing his mind and giving the report in which he has mentioned all these things that ସେ ଯାଇଥିଲା, ଇଏ କଲା, ଏମିତି ମତେ କହିଲା, ତେଣୁ ମୁଁ ତାକୁ ସନ୍ଦେହ କରୁଛି। Thereafter, tied a stone on the breast and waist of the deceased by wire and threw him in the Nile. Number here, the Ayo, what's that dead body? It weighs 40. Second para, 8th line from the top. I managed to bring the body out of the water and found both the knee and waist of the deceased were tied electric wire and then tied with the concrete slab. Here he stays stone on the chest and waist. No, the inquest report of Harper. Inquest report, knee and waist. It is I witness stone in the chest and waist. ମୁତାଫାର ଅଣ୍ଟା ଓ ଆଣ୍ଠୁରେ ପଥର ଓ ସିମେଣ୍ଟ କଂକ୍ରିଟ ଇଲେକ୍ଟ୍ରିକ ରସି ଦ୍ୱାରା ବନ୍ଧା ଯାଇ ପାୟା ଥିବାରୁ ଏହା ଏକ ହତ୍ୟାକାଣ୍ଡ ବୋଲି ଜଣାଯିବ। ସର୍କମଷ୍ଟାନ୍ସ ଅଫ ସିଜର। ତେଣୁ ଛାତିରେ ବନ୍ଧା ହେଇଛି, ଛାତିରେ ଚେଷ୍ଟ ଆଣ୍ଡ ୱେଷ୍ଟ। ଇଏ କହୁଛି knee and waist. No, this after throwing it, there is possibility of that say particular place ହସି ଖାସି ଯିବାର କାରଣ ଏଇଟା ଏଇ ଯୋଉ ଦି ଦିନ ପରେ ଏଇଟା ଇଏ ହେଇଛି ନା ମାନେ 10 ତାରିଖ ଘଟଣା ହେଇଛି ଏଇଟା 12 ତାରିଖ ହେଇଛି ତେଣୁ concrete slab is open. Concrete slab. After that, I was examined by the police. He has not stated in the examination sheet. Who has stated? No, PW4 is not stating. Thereafter, though I didn't disclose this before anyone, but subsequently I was examined by the police and I have given my statement before the police. That is lacking in his examination sheet. Right. He has stated this was the cross examination. No. Police agar କହିଥିଲେ ନା he should not have been asked this. No, that's a defense ପଚାର তিনি ବାହାର କରିଛି ତ cross examination ଯୋଉଟା ନଥିଲା ସେ କହୁଛି ନା ଯେହେତୁ ଧମକେଇଲା ମୁଁ କାହା ଆଗରେ କହିବି page 33 you have stated that police came to me and examined me. I have stated I have given my statement before the police. Kūčių prosakyčių Chipon dress pinkelininkų. I don't know, so the type of dresses owned by the accused and the deceased. I have two reports. He was having a cloth back. I cannot show its color. Then he says he had the cloth bag inside his pocket. Defense was debarred from putting a question. And why he didn't ask anything to PW4? Ultimately, in the morning, he saw him with the happening. So in the evening. And thereafter, he left as we saw from the LCR. And as indicated in the order sheet. And because he and his wife, after that incident, left the village, he could not be produced for his custody for examination. Is 43%. 40 on the surface code. So that goes next number 3. IO. Not 40, 45, 45. Is not a family. That might be the reason for the uncle to call from the What other decision you want to place, Mr.
No. Not, the part of extrajudicial conference. Before that, I'm begging a pardon. I have no personal system, so I note down the citation along with the paragraph.
Okay.
My lord, as a part of the extrajudicial confession, before the person who is not close to the appellant, my lord, in that aspect, I am pressing that one Kailas versus State of UP, AIR 1994, AC 470.
Kailas versus
State of UP,
hmm.
AIR 1994, SC 470.
470.
My lord.
470 to?
Again, 470.
What has been stated there?
In that, it is stated that where the accused allegedly made extrajudicial confession about 10 to 20 days
Just a minute.
after.
Hey. Boy King. Why didn't you collect the books from the Learning Council?
It is stated that where the accused allegedly made extrajudicial confession about 11 to 20 days after the commission of the crime and there was no apparent reason for accused to do so, the confession was held to be doubtful.
In this case, when the confession was made?
My lord, there is a time gap that he is arrested on
PW
6. PW 6.
Come to page 37.
Right.
Has he stated when that confession was
My
made?
lord, that is not present. That he
Because accused was arrested more than 3 months after the occurrence.
My
Because the occurrence took place on 10th, FIR lodged on 12th, accused was arrested on 25th. Right?
Sir.
25th July.
Right.
So it is more than 3 months. So what that witness says, PW6, that when that extrajudicial confession was made.
My lord, he stated in when he go for the second time to Rantandi, he stated so.
No. Page,
My lord,
page 37, fifth line. I accompanied so-and-so police to Tata in search of the accused. Just read it that portion.
Reading the cross-examination.
No, you can read the past chief examination. I accompanied, সেটা হচ্ছে important. I accompanied, read it, 4th or 5th line. Belpad police, chief examination.
Thereafter, the accused remained absconded. I accompanied Belpahar police to Tata in search of the accused, but could not find him. Thereafter, I went to my village where I found the accused. In the village, the accused disclosed to me that they had committed murder of the nephew of Vijay Bodra.
So then he was declared hostile. Then you come to the cross examination. କେବେ ଦେଖାହେଲା କଣ ହେଲା କେତେ ଦିନ ପରେ he has not stated in the examination.
No. I am working in company since 2003. I left for the village during March and returned in the month of May. I cannot say when I heard from whom the death of the deceased. I cannot say how many.
Pause for a moment. From March to May, he was not available in his own village.
Right.
Yes, proceed.
I Uh,
I
I
cannot say
cannot
when I
say
heard.
when I heard and from whom about the death of the deceased. I cannot say how many nephews of Vijay Bodra. I know that the nephew of Vijay Bodra was killed. I was told by police about the case. I visited Tata and Ramtandi and then Chaibasa. I paid by the company to go to my village and Chaibasa, but the expenses were borne by the police when I visited Tata. We found the accused at Tata on the third occasion.
Yes.
I cannot say the date and day, month when we found the accused. The accused was found at Uditpur. I cannot say the
ଟାଟାର ଗୋଟେ ଉଦିତପୁର ବୋଲି ଜାଗା
I,
ସେଇଠି ବୋଧେ accused ସାଙ୍ଗରେ ଦେଖା ହେଲା।
I,
CIC କହୁଛି the accused was found। ହଁ ତାପରେ କଣ କହୁଛି?
mine. I cannot say the particular area Uditpur where the accused was found. I cannot say the type of dress the accused had put on at that time. The accused confessed before me at Ramtandi when I had visited for second time. I disclosed it to Belpahar police when the accused told me about this in the village. I did not disclose it to any villager.
ନାଇଁ ଏଇ ଯୋଉଟା ଦେଖନ୍ତୁ ତା ପୂର୍ବରୁ ସିଏ କହୁଛି ତିନିଟା ଜାଗାକୁ ଯାଇଥିଲା।
Yeah.
ଗୋଟେ ହଉଛି ସିଏ ଟାଟାକୁ ଯାଇଥିଲା,
Okay.
ଆଉ ଗୋଟେ ରାମତଣ୍ଡିକୁ ଯାଇଥିଲା, ଆଉ ଗୋଟେ ଚାଇଁବସାକୁ
Yes.
ଯାଇଥିଲା ହେଲା। ହଁ I was paid by the company to go to my village। village ହେଲା ରାମତଣ୍ଡି ହେଲା and ଚାଇଁବସା। But the expenses were borne by the police when I visited Tata. We found the accused at Tata on the third occasion. I cannot say the day, date, and month when we found the accused. The accused was found in Uditpur. I cannot say the particulars also. The accused confessed before me at Ramtandi। ତାମାନେ ଯଦି ରାମତଣ୍ଡିରେ ତାଙ୍କ ସାଙ୍ଗରେ ଦେଖା ହେଲା, ରାମତଣ୍ଡିଟା ହଉଛି ୟା ନିଜ ଗାଁ। ତା ପୂର୍ବରୁ ତା ସାଙ୍ଗରେ ଦେଖା ହେଇଥିଲା ବୋଧେ ଯେତେବେଳେ ଟାଟାକୁ ଯାଇଥିଲା। Page 37%. I accompanied the Belfast police to Tata in search of the accused, but could not find him. Thereafter, I went to my village where I found the accused. Why didn't he, when admittedly before that, he went along with the police to search the accused? Why didn't he inform the police immediately after he saw him at his village? No, I would have he should have. The village IP person disclosed me that he has committed the murder of the so it is permitted. I accompanied Belfast police to Tata in search of the accused but could not find him. Thereafter, ତାପରେ ସେ ଗାଁକୁ ଗଲା, ସେଇଠି ତାକୁ ଦେଖିଲା, ସେଇଠି ତା ଆଗରେ ସେ confess କଲା ବୋଲି କହୁଛି। Yes, but why he didn't inform the police when admittedly he was assisting the police to trace out the accused and arrest him? I know that nephew I was told by police about the case. I visited Tata and Ramchandi, then Chaibasa. I visited Tata and Ramchandi and then Chaibasa. प्रथमे Tata, তারপর Ramchandi, then Chaibasa. When the statement of this PW6 was recorded, his name is Madhusudan Podra. Madhusudan Podra's statement.
610 signature from the signature seems like 610.
27/2004।
6th day of October 2005.
अच्छा एक्स्ट्रा जुडिशियल कन्फेशन स्टेटमेंट ଦେଇଛି 20/7/2004। said the date, day, and month when we found the accused. You put it as a file, this is a full Jagger file that he not said. So why is it accompanied police? Something so advanced like the police or promoter during the process. So the police don't friendship. So the sovereign but yes, anything?
My lord, as a part of extrajudicial control, I'll go through four decisions. My lord, first is that delay in 18, and second is that, my lord, one, Tarsim Kumar versus Delhi Administration 1955, CRLJ 470.
On what point that is?
My lord, that stated that extrajudicial confession made before stock witness who was casually knowing the accused was held to be not acceptable. Here, he is as a working for the police. So, in that aspect, I am considering that he is a stock witness.
No, stock witness does
Yeah.
not mean that one who is assisting the police on a particular in a particular case.
Right.
Stock witness means he might be witness in number of cases.
Cases.
As a prosecution witness, he might be. So that was the observation that when a witness uh, becomes a stock witness, he becomes like a court bar.
Right.
कोर्ट को आसिला एकला सो से भलिया विटनेस को विश्वास करिबा उचित नुहे सहजरे तेणु here in this particular case he has just accompanied once to the as per his version
Right.
थरे मात्र सी टाटा को पुलिस संगे जाइछि बाकी आउ कुआडे जिबा कथा पुलिस कहूनी माने
Right.
सी कहूनी
Right.
तेणु एवं टाटा रे आ संगे अक्यूज संगे देखा हिछि मध्य किंतु डिस्क्लोजर टाटा रे हेनी डिस्क्लोजर हिछि आ गां रे इज इट दैट करेक्ट
Right. Well, another is that one Bansidhara Nandi versus State of Odisha.
जस्ट अ मोमेंट
Right.
we found the accused Tata on the third occasion माने ये जो तीनटा ने मु जाइछि ये जो थर्ड occasion ता पूर्व ये रे कहले आपको की पर टाटा ये देखो I visited Tata and Ramchandra and then Chainkosa. But in third occasion the Tata I was paid by this one so on to go to that. But I visited Tata and so on so on. It is also on the third occasion Tata. We found the accused on Tata on third occasion. Maybe that टाटा को तीन हाँ टाटा को तीन थर जाइछन्ती तृतीय थर पाइछन्ती टाटा we found at Uditpur. But I cannot say the date, day and month when we found the accused. The accused. At Tata there was no confession. The confession was made in the village of the PWC. Admit করছো মার্চ টু মে when I visited for the second মার্চ টু মে পর্যন্ত গাঁরে নথিলা সে না 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 বিভিন্ন পারাত্রি I left for the village I am working in the company since 2003. I left for the village during March and returned from the company में थिला गाँरे एठी थिला so जदि ये जो पर्टिकुलर लाइन टा आसुनी मिस्टर त्रिपाठी ये जो क्रॉस एग्जामिनेशन जो सेकंड लाइन टा आसी पारा पेज 38 देखंतु पीडब्ल्यू 6 रो जे सी गोटे कंपनी ने 2003 रु चाकरी करथला where this accused is also right yes तार नेक्स्ट लाइन टा होची बहुत इंपोर्टेंट I left for the village during the March and return in month of May हला तेणु cannot say when I heard and from him about the death of the deceased, when he's admitting that he's saying that the accused confessed before him. So ଯଦି ସିଏ ତାପର ଲାଇନରେ କହୁଛି ଯେ ମତେ କନଫେସନ ଟା ହେଇଥିଲା କୋଉଠି ନା ଭିଲେଜ ରାମତଣ୍ଡି ତା ନିଜ ଗାଁରେ ହେଇଥିଲା।
Yes.
ସେ ନିଜ ଗାଁରେ ପ୍ରେଜେଣ୍ଟ ଥିଲା ମାର୍ଚ୍ଚରୁ ମେ ଭିତରେ, ରାଇଟ?
Yes.
ତେଣୁ ଯଦି କନଫେସନ ହେଇଥିବ ତାରି ଭିତରେ ହେଇଥିବ। ତାପରେ ସିଏ ପୋଲିସ ସାଙ୍ଗରେ ବିଭିନ୍ନ ଜାଗାକୁ ଯାଉଛି ଏବଂ ପୋଲିସ ଇନକ୍ଲୁଡିଂ ଟାଟା 3 ଥର ଆଟଲିଷ୍ଟ ଯାଇଛି, କିନ୍ତୁ ସେ ପୋଲିସ ପାଖରେ ତାର ଷ୍ଟେଟମେଣ୍ଟଟା ଦଉଛି 20/7/2004 ରିଗାର୍ଡିଂ ଏକ୍ସଟ୍ରା ଜୁଡିସିଆଲ କନଫେସନ। ତ ଯଦି ଘଟଣା ସିଏ ଜାଣିଲା ଇଏଠୁ ଆକ୍ୟୁଜ ଟୁ ଡ୍ୟୁରିଂ ଇନ୍ ବିଟୱିନ୍ ମାନେ ଏପ୍ରିଲରେ ଘଟଣା ତ ହେଲା ନା, ତେଣୁ ଏପ୍ରିଲରୁ ମେ ଭିତରେ ଡିସକ୍ଲୋଜର ହେଇଥିବ, ଏପ୍ରିଲରୁ ମେ ଭିତରେ, ରାଇଟ? ଯେତେବେଳେ ଗାଁକୁ ଯାଇଛି ତାରି ଯଦି ଏଭିଡେନ୍ସ ଆକ୍ସେପ୍ଟ ହୁଏ। ସୋ
ନାଇଁ ସେ କହୁଛି ଥାର୍ଡ ଟାଇମ ଡିସକ୍ଲୋଜ ଯେତେବେଳେ ଗଲା ଖୋଜିବାକୁ ପୋଲିସ ସାଙ୍ଗରେ ସେତେବେଳେ ଡିସକ୍ଲୋଜ।
ନାଇଁ ସିଏ କହୁଛି ଗାଁରେ ମୋ ସାଙ୍ଗରେ ତାର ଦେଖା ହେଲା, ସେଠି ମୋ ବିଫୋର ମି ହି କନଫେସ୍ଡ। ୟୁ କମ୍ ଟୁ ଦ୍ୟାଟ୍ ଲାଇନ୍ସ ତଳୁ ଆଣନ୍ତୁ 1 2 3 4 5 6 7 8 line from the bottom. The accused confessed before me at Ramtandi when I had visited for the second time. ହେଲା?
Yes.
ତେଣୁ ସେ ପର୍ଯ୍ୟନ୍ତ ଯଦି ଏଇଟା ତାର ଷ୍ଟେଟମେଣ୍ଟ ହୁଏ, ତେଣୁ ତା ପୂର୍ବରୁ ଯୋଉ ଯୋଉ ଜାଗାରେ ଆକ୍ୟୁଜ ସାଙ୍ଗରେ ଦେଖା ହେଇଛି, ଥରେ ଦେଖା ହେଇଛି ଟାଟାରେ, ଯୋଉଟା ଥାର୍ଡ ଥର ଭିଜିଟ କଲା ବେଳେ, ସେତେବେଳେ ତାମାନେ କିଛି କନଫେସନ ହେଇନି, କନଫେସନ ହେଇଛି ଆର ଗାଁରେ। ବଟ ଗାଁରେ ଯଦି କନଫେସନ ହେଲା, ଗାଁର କନଫେସନ ଟା ହେଇଥିବ କେବେ ନା ଘଟଣା ପରେ ଆଉ ଗାଁରେ ଥିବା ଭିତରେ। ଇଏ ଗାଁରୁ ଫେରି ଆସିଛି ମେରେ, ଯୋଉ ଲାଇନ ଟା ଦେଖା ହେଲା ଯୋଉଟା
Yes.
ଆପଣଙ୍କୁ 38 ତାମାନେ ମେ ଭିତରେ ଯଦି ତା ପାଖରେ କନଫେସନ ହେଲା, then again he made the statement before the police on 27/2004. That was the date of recording of that 161. ସେତିକି ବେଳେ extrajudicial confession ଭିତରେ କହି। So is it not delayed disclosure before the police, or it is just a afterwards he is making out a story, even though he was in company of the police assisting in
Yes.
the investigation, knows about the occurrence prior to the March by way of extrajudicial confession and disclosing it in July 2004. So that is one of the factors. In the examination, the chief is saying that I went to Tata police. Thereafter, I went to my village when I found the accused. In the village, the accused disclosed to me that he had committed murder of the nephew of so and so. But again, contrary to that, in the cross-examination is saying, I cannot say when I heard and from whom about the death of the deceased. I cannot say how many nephews of Vijay so and so. I know that the nephew of the Vijay was killed. I was told by the police about the case. So
Now, prior to visiting Tata, he was informed that the deceased was killed.
I was told by police about the case.
Yes.
I visited Tata and representative, then so and so. I was paid by the company so and so. We found the accused at Tata. Tata को accused पाइले से कुछ Tata ऐसी कौन Tata रू फेरी की मते गाँव रे से कहला। Tata रू फेरला परे गाँव रे बहुत सारी तार देखाला से बत कहला। कहीं ना अपन देखोंतु आई विटनेस रो वर्सन अवेलेबल थिला, तापरे accused को खोजा चालीची, accused संगरे टाटा रे देखा हला, पुलिस तो ताकू सी टाटा रे ही अरेस्ट करथांदा। तापरे आउ कोठी स्कोप थिला से आसिकिनी गाँ को रे ताकू accused को माने संगरे मिसिवार एवं सेठी एक्स्ट्रा जुडिशियल कन्फेशन दबार।
Yes.
से कहूनी कि मु टाटा जेतेबेले जाईची पुलिस संगरे जाईची।
Yes.
तेणु टाटा को जाईची 3 थर, तृतीय थर accused संगे देखा हला। तो पुलिस तो ସେଇଠି ଆରେଷ୍ଟ କରିଦେଇଥାନ୍ତା। ତାପରେ ଆଉ ଗାଁକୁ ଇଏ ଫେରିଲା, ଟାଟାରୁ ଆସିଲା ପରେ କହୁନି ମୁଁ ଗାଁକୁ ଆସିଲି, ସେଠି ଆକ୍ୟୁଜ ମତେ କନଫେସନ କଲା। ଆଉ କୋଉଠି ଆଉ ସେଠି ତ ଆରେଷ୍ଟ ହେଇଯାଇଥାନ୍ତା। ତାମାନେ
The IO is silent about that.
ହଁ ଆଇଓ ମାନେ ଆ ସାଙ୍ଗରେ ଯାଇଥିଲା ଟାଟାକୁ ଇଏ କରିବାକୁ, ସେଗୁଡାକ ସବୁ ଟୋଟାଲ ସାଇଲେଣ୍ଟ ଅଛି।
Pura silent.
ହଁ
And the accused was arrested in Mohanpur, that is in his in-law house.
This IO has not stated anything to have gone anywhere like Tata with this gentleman, PW6.
କୋଉଠି କହିନି?
IO approached 2 numbers of concrete slabs. Eyewitness, that boy, he says, Pathara. And it was tied to the chest and waist. Where the IO says it was tied in the knee and waist. And the reason for killing, who may be, might be at page 45, the suggestion. Without any reason, somebody having good term with another, why he should kill? There must be some reason.
If the
And while after committing murder, somebody going with his wife and that same boy for fishing, also a story seems to be
The
unbelievable.
boy might have not released by that accused till the evening. That may be one factor.
After all, we are human beings. After somebody is killing, ଆପଣ ମୁଁ ଚାହିଁଲେ ଜଣକୁ ମାରି
ନା।
ପାରିବନି। After killing somebody without any intention, and again going with his wife for fishing to catch fish. The boy. You are placing that Kailash, na?
my lord, Kailash
Kailash
versus state of
which
UP.
paragraph you are placing?
My lord, last two paragraphs, 4 and
Paragraph 4.
my lord.
Which said that extrajudicial confession is the main circumstance on which the prosecution facing Jason speaks about it. It belongs to the person himself. It is basically on that principle that when somebody is making a disclosure, so the uh, if anything, he expects that he will get some kind of help, or he has very closely related, then that is otherwise. When he has committed the crime, you would not go and disclose before
To anybody.
anybody. So
Absolutely.
that is how in this case.
In this case, that disclosure was made before the colleague,
PW6 was working in that
company with colleague,
So,
and they should have cordial relationship.
uh, appellant and except that they were in the company, same company.
Yes,
Um,
they might have cordial relationship, but why the accused should disclose before you?
no,
And they belong to one village.
uh, the accused co-villager, there is no dispute. Say same
Ramchand.
हाँ से नहीं नहीं ସେ କହୁଛି ପରା ଏଠି accused is my co-villager
Yes,
ତାର
yes.
second sentence ନାଇଁ ନାଇଁ ସେଇ ଗୋଟେ particular company ଚାକିରି କରୁଥିଲେ ବୋଲି କିଏ କହୁଛି ସିଏ କହୁଛି
I am working in the company.
company ଯେ କୋଉ company ଯୋଉ
ସେଇଟା
company
ଆଉ କିଛି ନାହିଁ ସେଇଠି
ହଁ
ପାଖରେ।
ସେଇ ଗୋଟାକ ଯୋଉ companyରେ accused ଚାକିରି କରୁଥିଲା ସେଇ company PW6 ବି ଚାକିରି କରୁଥିଲା
ସେଇଟା କୋଉଠି ନାହିଁ ସେ
କାରଣ evidence ଅଛି ये accused ଗୋଟେ company ଚାକିରି କରୁଥିଲା PW6 ବି ଗୋଟେ company ଚାକିରି କରୁଥିଲା but whether it is the one and
same company.
ସେଇଗୁଟା କହୁଛି but still then there are many what he has pointed out and there are many missing links and
Yes,
doubt is created about that something might have been uh, so that is why
One of the prosecution witnesses has stated before the court below as to the reason of
the
committing the
motive
crime.
is not there. Motive is not there. That's
କାରଣ ସେମାନେ ବାର୍ଡ ହଣ୍ଟିଂ ପାଇଁ ଯେତେବେଳେ ଯାଉଛନ୍ତି ମାନେ ସାଙ୍ଗ ହେଇକିନି ସେଇଟା ଗୋଟେ ସର୍କମଷ୍ଟାନ୍ସ ଯୋଉଟା କି ଦେଖୁଛି ଯେ ଭଲ ସମ୍ପର୍କ ନଥିଲେ ଜଣେ ଡାକିଲେ ଅନ୍ୟ
ଡାକିଲେ
ଜଣେ କାହିଁ ତା ସାଙ୍ଗରେ ଯିବ ତେଣୁ ସ୍ୱୀକାର କରିବାକୁ ପର୍ଟିକୁଲାରଲି ଆଉ
And if somebody requests his friend to go for hunting with an intention to kill him, why he should carry a third person with him?
just person both of you so that can JCRLA number 62 of 2006 the appellant Pradhan Bodra faced trial in the Court of Additional Session Judge Jharsuguda in ST case number 15 of 2004 for offense punishable under section 302 and 201 of the Indian Penal Code on the accusation that on 10/4/2004 in between 12 noon to 2 p.m. near Lilari Nola under Belpad police station in the district of Jharsuguda, he committed murder of Motaka Purti, bracket hereafter the deceased, and also knowing and having reason to believe that the offense has been committed, he caused the evidence connected with the said offense to disappear by throwing the dead body of the deceased in Nilari Lala with intent to screen himself from legal punishment. The London trial court found the appellant guilty of the offences charged and sentenced him to undergo imprisonment for life and to pay a fine of rupees 5,000, in default to undergo imprisonment for 3 months under section 302 IPC, and RI for 1 year and to pay a fine of rupees 1,000 in default to undergo RI for 1 month under section 201 of the Indian Penal Code. And the sentences were directed to run concurrently. Next para. PW2 Prafullo Kumar Roy had been to Lilari Nala on 10/4/2004 to attend call of nature, and he saw a dead body floating in the water. He could not identify the dead body, and he reported about the same at Bondhabahal outpost, Orali, and Bondhabal, the police officer of Bondhabal outpost in turn informed the matter to Belpar police station. The officer in charge of Belpar police station, namely Ashim Kumar Panda, bracket PW7, registered Belpar UD case number 1 of 2004, proceeded with the inquiry, deputed one constable to the spot to guard the dead body, made the station diary entry. After reaching at the spot, he found the dead body of an unknown person floating in the water. He managed to bring out the dead body out of water and found both the knees and waist of the deceased were tied by electric wire and also with concrete slab. At that point of time, Vijay Bandra, the uncle of the deceased, came and identified the dead body to be that of the deceased. Accordingly, inquest report Accordingly, on 12/4/2004, in between 1 p.m. to 1:40 p.m., the inquest was held over the dead body, and the inquest report Exhibit 2 was prepared in presence of PW2 and the informant, Vijay Bandra. The dead body was also sent for post-mortem examination in the said UD case. And one Habildar escorted the dead body for such purpose. On the very day, that is 12/4/2004, at about 2:15 p.m., Vijay Bandra lost the report before PW7, orally, which was reduced to writing, and the contents thereof was read over and explained to the informant, who signed the same, and it was treated as FIR, bracket Exhibit 6. In the first information report, the informant stated that the deceased was staying with them and he developed friendship with the appellant who was staying in the neighborhood. And both the appellant and the deceased used to go to different places. On 10/4/2004, at about 12 noon, the informant found the deceased to be accompanying the appellant to some place. And when the informant made a query to the deceased, he told that he was going to for bird hunting purpose with the appellant. The informant found the appellant was holding red red color electric wire. One boy aged about 10 years was also staying in the same village, also accompanied the appellant and the deceased, whose name was Gardi Saya bracket PW4. After the informant returned from his duty in the evening hours, he found the appellant, his wife, and PW4 were returning after catching fish, and seeing them, the informant asked the appellant about the whereabouts of the deceased, to which the appellant replied that he had left the deceased at Goudapada. The deceased didn't return back home. In that night, and the informant searched for him at different places. And on 12/4/2004, the informant received some message that the dead body of an unknown person was lying in Lilari Nala. Accordingly, he proceeded to that spot and found that the police had already arrived there and they were making inquiry. The informant identified the dead body to be that of the deceased. And further found that in his waist and knee portion, stones have been tied with a plastic electric wire. There were injuries on the head, seeing the condition of the deceased and the manner in which his dead body was lying. The informant suspected that that it was a case of murder, and he suspected the involvement of the appellant in the commission of murder of the deceased, and accordingly lodged the report before PW7. On the basis of such report, bail part PS case number 35 dated 12/4/2004 was registered under section 302(201) of the Indian Penal Code against the appellant. During course of investigation sub para, PW7 searched for the appellant, so also the boy who had accompanied the appellant and the deceased towards Nilari Lala. During search of the house of the appellant in the slum area, he recovered red color electric fare and prepared seizure list exhibit 9 in presence of the witnesses. PW7 found the boy Gardi Sayan, bracket PW4, and examined him. The Habildar who had escorted the dead body for postmortem examination produced the electric wire, two concrete slabs, the wearing apparels of the deceased before PW7 at the police station, which were seized as per seizure list exhibit 1. No.
For the cross-examination,
Cross-examination over here, I'm mentioning about the chief examination what he has stated.
seizure list for the complex lab.
The PW7 visited the employer of the appellant and verified the attendance register for the month of April 2004 and seized the said register, where he found that the appellant was absent from his duty with effect from 8/4/2004 and had not resumed till the date of his verification, that is 27/2004. And accordingly, the attendance register was seized as per seizure list exhibit 5 and it was handed over in the Jima of one Srivacha Kumar Behura. The PW7 made a query to the doctor who conducted postmortem examination as to whether the injuries noticed on the person of the deceased would be possible by the concrete slab MO1 or not, the doctor, as per his report by exhibit 4, reported that death could be caused as a result of assault by MO1. PW7 made a prayer before the SDGM Jharsuguda on 28 2004 to send the material exhibits for chemical examination. And received the C report by Exhibit 11, and on completion of investigation, he submitted charge sheet on 3/9/2004 under section 302-201 of the Indian Penal Code against the appellant. In order to prove its case, the prosecution examined 7 witnesses. Name those witnesses and quote them. The prosecution also proved 11 documents, mention it. 3 material objects were proved from the side of the prosecution. The defense plea is one of denial. The London trial court, after assessing the oral as well as the documentary evidence on record, came to hold that the evidence of only eyewitness (PW4) to the occurrence can be relied upon to base a conviction. It is further held that the evidence of PW2 about the discovery of an unknown dead body in Lilari Nala, the evidence of PW7, the IO, the FIR Exhibit 6, the evidence of PW4 and PW6 together unerringly prove that the appellant is alone the author of the crime. The court further held that the inquest report Exhibit 2 and the postmortem report Exhibit 3 proved that the deceased was first hit on the head, which caused the death, and then his dead body was thrown into the water only with a view to cause disappearance of evidence of murder, and accordingly held that the prosecution has established the charges under section 302-201 of the Indian Penal Code against the appellant beyond all reasonable doubt. Miss Agnisikha Roy, you are Roy, na? Okay.
Roy.
R
R-A-Y.
R-A-Y, R-A-Y, Roy. London Council appearing for the appellant contended that the eyewitness account of the child witness PW4 is not believable in view of his delayed disclosure before police about the occurrence, and more particularly when there was every chance of tutoring to such witness. The London Council argued that the London trial court, without noting down the questions and answers which it put to the said witness, came to the conclusion that the witness has clear understanding to give rational answers. It is argued that since what are the questions put to the witness and what answers have been elicited from him are not available on record, this court would not be a position to hold PW4 to be a competent witness. It is further argued that from the materials available on record, it indicates that the relationship between the appellant and the deceased was very cordial, in as much as they had gone together for bird hunting, and no motive behind the commission of crime has been established. The Lennon Council further argued that though it is stated that extrajudicial confession has been made before PW6 by the appellant, but the place where it is alleged to have been made is a doubtful feature, and moreover, this witness has belatedly disclosed about such disclosure before the police, which is another factor not to place any reliance on his testimony. The Lennon Council further argued that though it is the prosecution case that the appellant was absconding from the date of occurrence till he was arrested on 25/7/2004, and in that respect, the investigating officer seized the attendance register of a company for the month of April. But the said attendance register was not produced in court during trial. And moreover, the attendance register for the month of May, June, and July 2004 were not seized by the investigating agency. The Lennon Council further argued that even though some plastic robe was seized from the house of the appellant as deposed to by the investigating officer, but unless there is evidence that the very same wire has been utilized for tying the slabs oblique stones on the west oblique legs of the deceased, the recovery becomes immaterial. The Lennon Council further submits that if the appellant had a motive to commit the crime, he would not have taken PW4 with them to see the occurrence and be a witness in future to depose against him. It is further argued that the so-called extrajudicial confession, se joti extrajudicial confession seti gote lekhi debe, seti 88 insert kar debe, stated to have been made before PW6 is also not acceptable on the ground that there is no evidence of closeness between the two, and so that the appellant would repose confidence on PW6 to make such disclosure. Land Council further argued that when the informant was present and the inquest report was prepared on 12/4/2004 in between 1 p.m. to 1:40 p.m. and the inquest report, in the inquest report, the informant is a signatory and he has not entertained any doubt against the appellant, and nothing has been mentioned therein in the inquest report. All on a sudden, after few minutes at 2:15 p.m., there was no reason for on his part to create doubt against the appellant, which is a suspicious feature which the prosecution has not explained. And therefore, it is a fit case where benefit of doubt should be extended in favor of the appellant. Land Council placed reliance in the case of Pradeep versus State of Haryana 2023 Live Law SC 501 and Kailash versus State of UP reported in AR 1994 Supreme Court 470. Mr. Priyabrata Tripathi led an additional standing counsel, on the other hand, supported the impugned judgment and argued that there is lack of any material on record that PW4 has been tutored by anybody to depose against the appellant. He submitted that the witness has clearly stated that at the spot he was threatened by the appellant not to disclose about the occurrence before anyone, and that might have been the reason for which he did not disclose before anyone, including the informant, and remained silent till the police came to him for examination. After the FIR was lodged, mentioning therein that PW4 also accompanied the appellant and the deceased for bird hunting purpose. The London Council for the state further argued that it appears that the appellant and PW6 are the co-villagers, and they were working in a company, and therefore the appellant might have reposed confidence on PW6 to make the extrajudicial confession. The Land Council further argued that after the occurrence, PW7 was searching for the appellant at different places, and even from the evidence of PW6, it appears that the police took him to Tata for searching out the appellant, and ultimately the appellant was arrested on 25/7/2004. କୋଉ ଜାଗାରୁ କଣ ଗୋଟେ କହୁଥିଲେ?
In-law,
କୋଉଠି ସେଟା ଆପଣ ପାଇଲେ?
ସେଟା ଆୟୁର
ଆୟୁର କୋଉ ଲାଇନଟା? ହଁ, he was arrested from from his in-laws house at village Mohanpur.
Hmm.
The Lennon Council further argued that the sole eyewitness PW4 has stated to have seen two blows given by the appellant on the head of the deceased, and the doctor conducting post-mortem examination has noticed the who is the doctor? The PW3 na?
3.
PW3 has noticed fracture of occipital bone, and the injury has been opined to be antemortem in nature, and therefore the ocular evidence is getting corroboration from the medical evidence. It is argued that since direct evidence is available, even the prosecution fails to prove any specific motive on the part of the appellant to commit the crime, the same cannot be a ground to disbelieve the prosecution case. And the London trial court cannot be said to have committed any illegality in convicting the appellant. Adverting to the contention raised by the London Council for the respective parties, let us examine the evidence on record as to how far the prosecution has successfully established that the deceased met with a homicidal death. Apart from the inquest report, the doctor's evidence, Dr. Bracket like the PW3's evidence is very clinching in that respect. PW3 conducted the postmortem examination on 12/4/2004, and he noticed the fracture of occipital bone of size 2 inch into half inch, which has been opined, and the injury has been opined to be antemortem in nature. And the age of injury was within 12 hours prior to the postmortem examination. The doctor specifically stated that there was corresponding injury to the fracture of the occipital bone, that is laceration of brain. However, no other internal injury was noticed, and cause of death has been opined to be due to hypovolemic shock due to intracranial bleeding and cerebral anoxia due to profuse bleeding, and the injury was opined to be sufficient in ordinary course of nature to cause death. The doctor has proved the postmortem report as Exhibit 3. He also examined the stone sent along with the dead body and opined that the injury on the deceased could be possible by hitting with the stone, bracketary MO1. In view of the evidence of PW3 and the PM report, bracketary Exhibit 3, coupled with the inquest report, we are of the view that the prosecution has successfully established that the deceased met with a homicidal death. The inquest report and the manner in which the dead body was found. Hello? Yes. Coming to the evidence of the star witness on behalf of the prosecution, who is none else than PW4. It appears that the Lenin trial court asked some general questions and found that that PW4 has clear understanding and gave rational answers. However, the court found that PW4 was having no understanding regarding duty of speaking the truth. Hence, no oath was administered to him. In the case of Pradeep Bracketry Supra, the Honorable Supreme Court held as follows, quote paragraph number 8, 9, and 10. In view of the ratio laid down in the said case, we are of the view that the Lenin trial court ought to have recorded the questions which have been put to PW4 and the answers given to such questions. And then the court should have mentioned his own observation basing on the question and answer that the witness was able to give rational answers and therefore is a competent witness. In absence of mentioning the questions and answers, this court is deprived of assessing as to whether the witness was a competent witness and to give rational answers to the questions put by the trial court or not, in as much as the finding of the Lenin trial court regarding competency of a child witness in view of the language of section 118 of Evidence Act is not final. However, the manner in which the witness has answered to the public prosecutor in his chief examination, so also face the questions of the Lenin Defense Counsel, can be a factor for this court, to assess as to whether the witness was a competent witness or not. Competent witness is one thing, but whether he's a whether he's a truthful witness or not is to be adjudicated basing on several aspects of the case. PW4 has stated that he himself, along with the appellant and the deceased, had been to the backside of their colony towards Dilari Nala for bird hunting. And the deceased was going ahead, followed by the appellant, and then he was following them. And near Nilali Lala, the appellant hit the deceased on the backside of his head with a stone, as a result of which the deceased fell down. And then again, the appellant hit the deceased at the same place. PW4 further stated that when he saw the assault, he started running out of fear, but the appellant threatened him to kill if he went away from that place. The witness further stated that the appellant thereafter tied a stone on the chest and waist of the deceased by the wear and threw the dead body in the Nala. And the appellant also warned him not to disclose to anyone and threatened to kill him. PW4 has identified the stone marked as MO1, so also the wear marked as MO2. In the cross-examination, he has stated that he had never gone to the jungle after coming to reside at Jupudi-Pada. Admittedly, he, after the occurrence, he disclosed before the police for the first time about the occurrence on 12/4/2004. In this case, the informant has not been examined. सब पारा कर ले. We find from the order sheet dated 17/1/2006 that the summons issued to PW1, a summons issued to informant, returned back with endorsement that he has left the place. And the public prosecutor, making no other sincere effort through the prosecuting agency, declined to examine the informant. If PW4 had accompanied the appellant and the deceased on the relevant day, and the deceased did not return back, and as per the FIR version, The appellant told the informant that he left him at Goudapada and in spite of that, the deceased didn't return either on 10th or on 11th of April 2004. The appellant should have, the informant should have confronted PW4 about the same, but it seems that no such effort has been made by the informant, which is conspicuously absent in the not only in the first information report but also in the evidence of PW4. This creates a doubt in our mind as to PW4 accompanying the appellant and the deceased. The explanation which he has offered regarding threat given by the appellant comma if any suddenly seems to have disappeared when the police approached him on 12/4/2004 and he gave his statement before the police. This creates a doubtful feature in the evidence of PW4. In the case of Kailas versus, oh, this is that is not there. Coming to the extrajudicial confession, which is stated to have been made before PW6, we find that the statement of PW6 was recorded by police on 27/2004, which is which is 3 months after the date of lodging of the first information report. PW6 has stated that the appellant was his co-villager and when the appellant absconded, he accompanied Belpad police to Tata for searching the appellant but could not find him. And then he went to his village where he found the appellant, and in the village, the appellant disclosed to him to have committed murder of the deceased. PW6 has been declared hostile by the prosecution. In the cross examination, he has stated that he was working in the company and he came to the village during the March and uh, returned to the company in the month of May. Therefore, if any confession was made to him by the appellant as per the chief examination, it must have been made after the lodging of the FIR, that is on 12/4/2004, till the till May end. However, the when the witness was accompanying the police to Tata, when PW6 was accompanying the police to Tata for searching out the appellant, and he was aware about the extrajudicial confession being made, his silence speaks a lot against his conduct and against his truthfulness regarding extrajudicial confession, in as much as is disclosing the same in July 2024, 2004. PW6 has stated that when he visited Tata, the expenses were borne by the police, and they found the appellant at Tata on the third occasion. However, he could not say the date, day, and month when he found the appellant. He stated that the appellant was found at Uditpur. If Chennai, since the appellant has been named in the FIR, and eyewitness PW4 has implicated the appellant in the crime, and the police is searching for the appellant and had gone to Tata, where they met the appellant. It is not understood as to why the appellant was not arrested at Tata. PW6 has stated that after he came back from Tata, he met the accused in the village where the disclosure was made. This goes contrary to the evidence elicited in the cross examination. Extrajudicial confession is, as such, a weak piece of evidence, and when the evidence is lacking about the closeness between the appellant and PW6, and there was no reason for the appellant to repose confidence on PW6, who is assisting the police in the investigation and going to search him out in connection with the case. To repose confidence on him and to make the extrajudicial confession. Therefore, we are not inclined to place reliance on the evidence relating to the extrajudicial confession. The evidence of the prosecution that the appellant was absconding after the commission of the crime is stated by none else than the investigating officer, who has stated that he visited the employer of the appellant, verified the attendance register for the month of April 2004, and seized the said register and found that the appellant was absent from his duty from 8/4/2004 and had not resumed till the date of his verification, that is on 27/2004. And accordingly, he prepared the seizure list of the attendance register by Exhibit 5, and he handed over the said register in the Jima of one Sri Bharat Singh Behura, the in charge of Motor Transport Wing, RCP, Junabag. The PW5 though stated about the seizure of the attendance register by police as per seizure list Exhibit 5 and proved his signature on the said seizure list, but he has not stated from which period to which period the appellant was absent. Moreover, the attendance register of the month of May 2004, June 2004, and July 2004 have not been seized nor produced in court. To verify such an important aspect regarding the statement made by the investigating officer, it was nonetheless the duty of the public prosecutor, while summoning the witnesses, to call for the attendance register, which was left out in the Jima of one Sri Bharat Singh Behura, to produce in court and to prove the same. The proving of seizure list of the attendance register without any oral evidence of either the owner of the transport company or any co-workers, and particularly in absence of proving the attendance register, it is very difficult to hold that the accused was absent, was not attending his work in the company, and he was absconding. When a vital document has been seized and not produced in court, in view of section 114 bracket G, the court can presume that had it been produced, it would have gone against the prosecution for which the same was not produced. There is absence of any motive behind the commission of crime, as rightly pointed out by the learned counsel for the appellant, in as much as the FIR indicates that they were good friends and they were moving together, and on the occurrence day also they had gone for hunting the bird. Therefore, what was the occasion on the part of the appellant to commit the murder is not established. It is, of course, correct that where direct evidence is clinching, trustworthy, believable, clear, cogent, above board, absence of proving the motive on the part of the prosecution cannot be a ground to disbelieve the prosecution case. But in this case, since we are doubting the version of the sole eyewitness PW4 and the motive is found to be absent, this is a factor which goes in favor of the appellant. लिखी नहीं अच्छा এটা লেখা है कि जो इनक्वेस्ट रिपोर्ट जो कहा था अगेंस्ट किसी सस्पिशन मतलब लिखी थी हां लिखा है लेगो हां another important feature is that when the appellant uh, when the informant was present when the inquest was held and he is a signatory to the inquest report and there is no mention in the inquest report doubting the involvement of the appellant in any manner in the crime in question. But few minutes thereafter, when the FIR was lodged, everything has been stated against the petitioner to be the perpetrator of the crime is a suspicious feature in the case. जो extrajudicial confession लिखले duty petition. In case of Kailash, it has been held as follows. से जो quote कर दे paragraph 4 and 5 पे duty quote कर. In view of the foregoing discussions, when important witness like the informant has been withheld, important document like attendance register has been withheld, the eyewitness account of PW4 is not believable, on account of his belated disclosure, the extrajudicial confession stated to have been made before PW6 is shrouded in mystery. The absconding of the appellant is not proved with clinching evidence, and merely because the doctor's evidence indicate that it is a case of homicidal death, and some plastic wire, electric wire, were recovered from the house of the appellant cannot be a ground to hold the appellant guilty under the offenses charged. In view of the foregoing discussions, we are of the view that the prosecution has miserably failed to establish both the charges, that is 302 and 201 of the Indian Penal Code, beyond all reasonable doubt. And therefore, it is a fit case where benefit of doubt should be extended in favor of the appellant. Accordingly, the jail criminal appeal is allowed. The conviction of the appellant under section so and so is hereby set aside, whether he is on bail or in custody.
Very well.
But the appellant seems to be released on bail by the order of this court dated 2/5/2014 in Miss Case number 13 of 2014. Is exonerated from the liability of the bail bond. The surety bond stands cancelled. Put a note of appreciation on Ms. Agnishika Roy and on Mr. Tripathi.
Hopeless.
Two 2023
What is the prayer in that revision?
for questioning of that,
Passing of
my lord, order passed by the Lord Court below,
what order was passed?
rejecting the, my lord, charge.
You
Against
discharge?
charge, yeah, discharge, my lord.
Give. Okay.
The
part-
order is there to be listed.
Pardon mention, my lord. Conviction 10 years, my lord.
Hmm.
Out of 10 years, 8 years, 7 months is in custody.
Bail.
Bail.
Lordship, criminal appeal for bail, Your
Tired of bail matter.
criminal appeal, my lord. Convicted for 11 years. 9.5 years already served.
Okay.
Me day for hearing, my
Hmm.
lord. Tired of anticipatory bail.
Lordship, maybe pardon, my lord. Item number 46.
Hmm.
A 10 years conviction, there is a delay of 5 days.
Yes, Mr. Das.
My lord.
It's a conviction matter and delay is 7 days as per the so delay condone admit for the trial court record, deposition copy to be supplied, interim applications for bail and stay to be considered after receipt of the trial court. Yes.
Supplementary list item number 1.
PM sir, they have not issued any receipt to that extent.
Hmm?
I've given copy.
What copy?
Address, press address, my lord.
Press address you have not given?
Given by my lord. They have not issuing this receipt. I've given.
When you given?
अरे भैया ନିଅ
ଦିଅନ୍ତୁ
ଏଇଟା ଆଉ ଗୋଟେ ନିଅ
କାହାର
ଆଉ ଗୋଟେ
ଆଡ୍ରେସ
ନିଅ
କାହାର ଆଡ୍ରେସ ଦବ?
ସେ ଯୋଉ ଦିଟା ଯୋଉ ଉତ୍ତମ ଉପାଧ୍ୟାୟ
ଓଜି
ହଁ ଦିଟା ଦେଇଛି ସାର୍ ଆଉ ଆଉ ଥରେ ନିଅ
local surety.
ହଁ
No,
ନାଇଁ ନାଇଁ
original appellant matter. His address was whatever is mentioned in the petition appellant memo petition matter. It was found to be incorrect. Okay. So thereafter matter directed to furnish the correct address. Right. That should be again to verify. Oh, he was staying on an encroached land, and the government, after demolition of the basti, has made the highway over that area. So that is why, all right.
he has given a
Press address you have given.
Yes, given. Already, sir, they have not issuing the certificate because issue receipt.
Achha,
And I have given
there
again.
are in this appeal there are two appellants.
Yes, sir.
So you have given
two
of both the appellants. Today, the Land and Council for the appellant supplied the address of correct address of both the appellants to the Land and Council for the state in court to seek some time to verify the same, put up this matter, give a date. Yes.
Matter number 4.
Please, my lord.
of the victim. Case of accident.
Oh, acid case, acid throwing. What is the ultimately he was found guilty under section
307 and 326. 9 years under 307 and 5 years under section 326. Both the sentences are directed on consecutively.
So it is 14 years.
14 years. Out of 14 years, I am inside custody since 2017.
Oh, dangerous. No, sorry. 17 means
6 years.
stayed there. Land counsel for the appellant. A state produced the photograph of the victim. The land counsel for the appellant seeks for an adjournment. Put up this matter in the week commencing from so and so. Yes. So, is a college girl. What you have done with that girl? Total life is. Why are you? Plastic surgery provision should have been there, Mister. Is a which case, which area it is? It here, Bhadrak area. Jagatsinghpur, sorry, Jagatsinghpur area.
He was aged about 25 years.
Hmm. Plastic surgery they available in number of hospitals. Good hospitals are there in Bhubaneswar, apart from Cuttack SCV. So you do not know whether the plastic surgeon has been consulted or not. So you just obtain instruction also that about that whether the a type of treatment has been provided or due to financial problems is not being. A young girl is after perusing the photograph of the victim. I direct the let the land council for the state obtain instruction as to what sort of provision has been made by the state for providing uh, medical treatment, particularly plastic surgery, to the victim. And the victim will be produced before the superintendent of SCB Medical College and Hospital, Cuttack, and she'll be examined by a team of doctors. And if proper facilities for or treatment so far as plastic surgery is available, then the same is to be provided immediately. Free copy of the order be handed over to the Land and Council for the state, which will be forwarded to the Superintendent of Police, Jagatsinghpur. You say victim is from Jagatsinghpur or what? Jagatsinghpur to do the needful. And area. Huh? Tirthol. Tirthol hele Jagatsinghpur asela na? Superintendent of Police, Jagatsinghpur. Matter to be listed in the week commencing from 26th February 2024. The Superintendent of Police shall submit a report regarding the medical treatment along with a copy of the report of the doctors of the SC Medical College and Hospital. Yes, free copy of the order be handed over to the Land Council. Yes.
Matter 11.
Next week.
conviction order where the learned trial court has convicted the petitioner for rigorous imprisonment of 10 years and for this offense under section 20B2C of NDPS Act. And my lord, the petitioner has already undergone more than 8 years. The custody certificate is also on the record at flag C, my lord. And my lord, during that when the petitioner was in jail, he has lost his parents. There is no surviving member in his family. And my lord, there is a long incarceration. My lord, I am humbly praying kindly suspend the sentence.
Mr. Have you got that custody certificate? The custody certificate is dated. What is the date of his? It's not like.
No, my lord.
No, it is with me, but 1912 এই ସେ କଷ୍ଟଡି ସାର୍ଟିଫିକେଟର ଡେଟଟା ଦେଖିଲ 19/12 ସେ ସାଇଡକୁ ରହିଯାଇଛି ମାନେ ସ୍କାନିଂ ହେଲା ବେଳେ କଟି ଯାଇଛି 2023 ନା 2022 ହଁ ଫାଷ୍ଟ ପେଜକୁ ଆସ ଲେଖା ହେଇଛି ସାର୍ଟିଫିକେଟ ନମ୍ବର 20 ଡେଟ୍ ହଉଛି ଏତିକି ପାଇଲ ଫାଷ୍ଟ ପେଜରେ ହଁ କଟି ଯାଇଛି Oh, what is the certificate dated? Have you got the certificate with you?
No, my lord. Right now, I have no certificate issued because
You have annexed that certificate with your application. But the problem is that, say, after that date, certificate number 20 dated 1912, whether it is 22 or 23.
My lord.
Have you got the custody certificate with you? No.
My lord, right now I have no custody
Then how
certificate, my
can
lord.
so
My lord, it's 2023. I got an instruction from my senior that he's not well today. It's of 2023, my lord.
1912-23.
Yes, my lord.
Okay, then this period is Mr. Tripathi.
Yes,
It is mentioned that A plus B plus C is 2922. So if you divide it 365, what is happening? How many years and 2922?
eight years.
8 years. So that means the sentence is
10 years.
Uh,
Ten years, fine, 1 lakh.
And this man is a local man or outside?
No, Madhya Pradesh.
Madhya Pradesh. So what is your instruction about the address verification?
That is not.
You have not taken?
Yeah, direction is not given.
Okay. So the obtain that make the address verification, and I am asking her to file the sureties, local sureties documents. So make the necessary verification. Had Miss Kiran Pandey, Land Council through virtual court, she submitted that out of 10 years of substantive sentence imposed by the Land Trial Court, the petitioner has already remained in custody for more than 8 years, which would be evident from the custody certificate annexed to the interim application. Land Council for the state, however, submitted that the petitioner is a man from Madhya Pradesh of Dhar district, and he may be given some time to obtain instruction as to whether the address furnished in the cost title is a correct one or not. Let the Land Council for the appellant supply the names and address of two local sureties who are interested to take the petitioner on bail along with the relevant documents to the Land Council for the state, on receipt of which the genuineness of the bailers and the authenticity of the documents shall be verified through inspector in charge of Nandapur police station. Yes, you supply the names, address, and so documents of the local sureties.
Please,
Yes.
madam. Oblige, madam.
Item number 22. This is for delay, my lord. The delay of 42 days to file appeal, my lord.
this petitioner was acquitted from the charge under section 302.
Yeah.
And was convicted for the offense under section 304 part 1 and 323 for 10 years.
Hmm.
My lord, he was custody now, my lord, more than 5 years and 3 months. Tribasi Mahanandia.
ପିବାସୀର ଆରେଷ୍ଟ ଦେଖୁଛି 25/8/2018।
Yes.
2018 ମାନେ 5 ବର୍ଷ ହେଇଗଲା।
5 ବର୍ଷ
5 years then 9, 10, 11, 12, 1. So it is 5 months. 5 years, 5 months.
Yes.
You have not been
I was not on bail during trial.
Not bail, right? Now eyewitness is there.
Yes,
Who is the eyewitness?
My lord, PW 1, 3, 4, 5 and 6.
Right. And doctor is?
My lord, doctor is my lord PW 22.
PW?
22.
So PW1 eyewitness এটা কোন দিয়েছি দেখাউন ঠিক আছে? Okay. Alleged incident so on the occurrence day morning, both the deceased and the informant were standing in front of their house. Accused came holding a lathi, told them that due to you, both is facing disturbance, and saying so he dealt a blow on the informant. And when the deceased came forward to protest his wife, the accused dealt blows on the left leg. As a result of which the deceased sustained fracture of his left arm, fell down. The accused then dealt blows on the right arm of the deceased with the lathi. Then the villagers gathered, including myself. Accused then entered into the house, which we are. So, Mr. Mishra,
Lordship.
the weapon of offense is lathi.
My lords.
And the body part on which the assault has been made is the left leg and right arm.
Lordship.
And they are also
And what is the doctor's evidence? Let us see.
my lord,
PW 22.
It is on removal of the bandage, I found the following injuries: lacerated injury of size 2 inch into 1 inch into bone dip, present on below left knee. Second is lacerated injury of 2 inch into 1 inch into bone dip, present below right knee. Then swelling, 4 swelling injuries, 4 swelling.
There was fracture of both the tibias and the fibula bones, my lord. Both the legs.
Dita see tanko କହିବାନ୍ ଯେ dita blow ଦିଆଯାଇଛି. ଯୋଉ ଆଇ ୱିଟନେସ୍ ଆକାଉଣ୍ଟ
Yes.
ଅଫ୍ PW1 ଆଟଲିଷ୍ଟ କହୁଛି ଗୋଟେ ଗୋଡରେ ଆଉ ଗୋଟେ ହାତରେ. All right. Heard the learned counsel for the petitioner, learned counsel for the state. The learned counsel for the petitioner submitted that out of 10 years of substantive sentence imposed by the learned trial court, the petitioner has undergone sentence of 5 years and 5 months. Placing the evidence of the eyewitness PW1 was stated that the petitioner assaulted on the right left leg and right arm of the deceased, which has caused fracture injury. As for the evidence of the doctor, bracket PW22, who conducted the post-mortem examination, and since there is no chance of early hearing of the appeal in the near future, the bail application may be favorably considered. Learned counsel for the state opposed the prayer for bail and praised the evidence of PW1 and PW22. considering the submission nature of accusation against the petitioner, sentence imposed, period already undergone by the petitioner in judicial custody, absence of any chance of early hearing, I am inclined to release the petitioner on bail, stay realization of fine.
Publish. Page number 26.
Yes.
May I please? The petitioner, along with three other
Deposition copy supply.
Yes, my lord.
Yes, item 26. What is the sentence imposed?
My lord, at page 36,
Hmm.
10 years. Your Lords. It is a case under section 20B2C.
20B2C, 10 years, and you are in custody for
4 years, 11 months, Your Lords.
4 years, 11 months. So you remain for another 1 month. We'll take up this matter in March. Learning counsel for the petitioner seeks for an adjournment. Put up this matter in the week commencing from 18th of March 2024. Week commencing, yes.
My lord, may I prefer the health condition of the petitioner is
Okay, health condition report be obtained through jail superintendent.
both. Obliged.
Item 27.
Yes.
May I please? My lord, two appeals are there, my lord, tagged, my lord. The CRL
2 under section 20B2C of NDPS Act. My lord, there was absolutely no allegation against the present petition regarding.
कौन पे आसीचंदी देखछन लिस्ट रे
Sir.
आपण मेरिट रे आर्गुमेंट कर देबे
There's a
124 दिन डिले हाई कोर्ट बार रो पैसा पेमेंट हेनी अन्य डिफेक्ट अछि से डिफेक्ट रिमूवल आपण स्टार्ट कला आर्गुमेंट ऑन मेरिट
copy has also not been served.
Have you not filed any interim application for condonation of delay?
My lord, yes, I have filed.
Konda could file kurjin. What is the IN number?
As,
You have not filed. You are not aware that what is the defect. Whether there is 124 days delay. There are number of defects in this, as pointed out by the stamp reporter. Land counsel for the appellant seek some time to remove the defects. Put up this matter after the defects are removed. Yes.
Number 30.
may appeal.
Yeah.
The present petitioner convicted under section 373 for a period of 20 years, manner that is running
अरे सेकंड आइटम आपण करिवे ना एडजमेंट नेबे
First, IA stay relation of fine. Only 2 years is in custody. 10 years conviction.
You want some order in that stay relation of fine.
Only.
What about the bail? You do not want to move it today. Okay. The appeal has been admitted. What is the conviction?
20B2C, 20B2C, 10 years.
Right. IA number 2377. It a second that like you. There shall be stay of relation of fine. All right.
Now 35.
A faster लिखी देवे non appeals करेगी नहीं. Put up this matter along with so and so कर दो. Yes.
Now 35.
Roy.
May I please, Your Lordship? There are 4 applications. My lord, in first application, my lord, all the applicants are convicted for 7 years.
Just a minute. Operative part is page number.
Operative part is, my lord,
internal page 40, running page 48.
Yes.
Okay. 7 years, 5,304, part 2 by 34, right?
Yes.
Then in default to undergo 4 months, all right. Then RI for 2 months. Under section 323 by 34, both the sentences to run concurrently. Okay. What is the name of the deceased?
Deceased is, my lord, Ajit Khotai.
Eyewitnesses are there.
PW2, my lord, who was there with the deceased at the time of incident.
What is the weapon of assault?
My lord, lathi, kick blow, fist blows, like that.
Died at the spot?
No, after 3 to 4 days, my lord, he was died. Incident took place on 26/11.
26/11.
Died on 29/11.
26/11 कौन?
20.
Died on?
29/11/20.
Who is the doctor conducted?
Doctor, my lord, PW12. 14. Only one. PW12 conducted the PM.
PW12. अच्छा. Staged wound, left parietal region, contusion, forehead. Okay. Heart was injured. So 2 injuries only noticed. How many persons participated?
My lord, 4 to 5.
5, my lords.
Everybody was holding the lathi or what?
No, my lord. What he says that PW2.
Because there are 2 injuries and both the injuries are on the head and left side head.
Yes.
So the first one is a staged wound, the second one is a contusion.
Contusion.
And so cause of death has been opined to be craniocerebral injury. Okay. So let us see the eyewitness account of PW. You said PW2, na?
PW2, yes.
Okay.
Sorry,
Thereafter, how many persons? I know all the accused persons.
PW6, my lord.
PW6 is the
because there
eyewitness who is
are
identified.
split up ST numbers. For that reason, PW6 is the eyewitness
who has been able to identify these persons.
Okay. Which paragraph said?
What should we take the second paragraph?
Second paragraph. When we approached Nuapalli,
yes.
drove his motorcycle towards so and so. I was driving a car. I applied the brakes, stopped my car. I asked Motan why he drove the motorcycle so and so. Madan Pal scolded, dragged away so and so. Thereafter, Madan and Satya beaten Ajit Patti. He is the deceased by means of a stick. So first he stated about in paragraph 2,
Madan
he
Pale
has stated about two persons.
Satyanarayan Polda.
Right, Madan and hey, Madan
Pale and Satyanarayan Polda has assaulted by means of
by means of stick.
Yes. Then Madan Pale called his son Chandan Pale.
No, it's all right. Then again in the third paragraph, same page, last two sentence.
Thereafter, all the accused person beaten Ajit Khoti to death by means of sticks and iron wristbands.
Okay. How many total accused persons facing trial?
Total, my lord, five.
So 5 persons participated in the assault, and these are the weapons. So 2 injuries were found.
Yes.
You are for whom? Informant?
No, he is the third. He is in third item.
The second item.
Second item.
Chandan Pale.
Yes.
Okay.
Chandan and Madan.
Yes, Mr. Judgment Hour. Judgment Hour. So in one way, this ocular version contradicts the medical.
Logic.
Only 2 injuries are there.
Yes.
5 persons assaulting mercilessly. So
6 persons. 6 persons.
6 persons.
What is the
Are the Land and Counsel for the petitioner, Land Counsel for the state? The Land and Counsel for the petitioner submits that bail kaun hala?
Bail during trial, they all are on bail.
The petitioner was on bail during trial, and he has never misutilized his liberty. Placing the evidence of eyewitness bracket PW6, it is argued that though he has stated 6 persons, 6 accused persons who have assaulted the deceased by means of stick and
stick and
iron
wristband.
But as per the evidence of the doctor bracket PW12, he noticed only 2 external injuries, both on the left forehead, left head for them, left side of the head, and therefore the ocular version is not corroborated by the medicals. Land Counsel further submits that there is no chance of early hearing, balance of convenience is in his favor, and therefore the bail application may be favorably considered. Land Counsel for the state oppose the prayer for bail, peruse the evidence of PW6 and PW12. Considering the submission nature of evidence adduced, fact that the petitioner was on bail during trial, absence of any chance of early hearing, I am inclined to release the petitioner on bail. There is an application for stay of realization of fine, so stay the fine. So same order in all the cases.
There are 2 ST numbers.
Kuthre.
Either split up so misegi korchand.
Tondru. Judgment avacham. ST number for 78 korala.
78 is that is CRLA 11332. My lord and
80 are ST number पकेगा और सेगुड़ा कर कौन ST number
Olga
अच्छा
in 1163
PW6 evidence सबूतेर समान
PW6
it should have been all the cases should have been ଗୋଟେ date ରେ judgment ହେଇଛି ତ
yes
ଆଉ ତ ଅଲଗା ଅଲଗା କଣ ପାଇଁ କଲେ एसटी केस नंबर आधे
स्प्लिट अप थिला बोली
हाँ हाँ स्प्लिट अप वाला जजमेंट है सेही गोटे जजमेंट
हाँ से गोटे नंबर रे कर
कारण एविडेंस जदी अलग अलग हेइथांदा मैटर इज डिफरेंट मानकर ए केस रे PW1 जे से केस रे PW6 हेइथांदा मैटर इज डिफरेंट बट यू सेड दैट द सेम ना सेमती किछि अछि कि
गोटे मिनट 40
खाली मते एई दीटा विटनेस कोन दे PW6 आधे रे जोटा ताधे सेया तो
No, Lordship, it's different. Man.
हाउ चला पूछन
बादल
आधे रे PW6 होची
बादल पात्र
हाँ बादल पात्र रो
हियर माय लॉर्ड PW7 इन ST नंबर 42
मते प्रथमटा रेला बादल पात्र डाक्टर होची डाक्टर ना कोन कोन बार नंबर
PW12 माय लॉर्ड
डॉक्टर लक्ष्मी अच्छा से जो बादल पात्र एथरे केते नंबर साखी एग्जामिन हला आरटारे ए सेकंड टा बार करो चंदन पल्लई
PW 14 आज्ञा आज्ञा ST 42
ने बादल हला PW7 आ एटा हला
PW7
डॉक्टर हला 14 हां एइटारे बाकी सब तक अन्य जो गुड़ाक रही जो कनेक्टेड मैटर गुड़ाक प्यारी मोहन देन सत्यनारायण परिडा एंड चंदन एती तो
ऑल ST 42
अच्छा एगुड़ाक होची लास्ट जो तीनटा बुझिले यारो ST नंबर अलगा दिस शुड बी ST नंबर 42 ऑफ 2021 आ से जो लिखिले ना PW6 एठी हे गेला PW7 राइट
मोर भी 42
आउ सब समान
मोर भी 42
सबुथरे बेल ग्रांट कर देबे स्टे ऑफ फाइन yes next
item 36
My lordship, yesterday I have filed the deposition.
taken up next week.
Lordship.
Huh? कोणता कोणाला जहाज ଏତିକି ଉଠେଇ ଦିଅ ଏତିକି ଉଠେଇ ଦିଅ ପ୍ଲସ୍ ଟାଇଡ୍ ଅପ୍ ଉଠେଇବ ଆଉ
Item 44. File for interim bail matter.
ହଁ
File for interim bail matter.
item
44 matter.
ହଁ
And for interim bail, mother is seriously ill man for that reason.
seek some time to obtain instruction, put up this matter.